In our day-to-day lives, we all make certain promises to our friends and family members. We all do get into agreements with other individuals. You must have also heard the term contract being used when your father is going to sign a contract with a property dealer. But what do these terms really mean in context of law? The term promise, the term agreement and contract. Come, let's understand in context of the Indian Contract Act of 1872. The Indian Contract Act of 1872 came into force on 1st September 1872. The preamble to the Act says that the Act defines and amends certain parts of law relating to contract. This Act is divided into two parts. The first part, consisting of Section 1 to 75, deals with general provisions relating to the law of contracts, and it is applicable to all types of contracts. The other part deals from Section 124 to 238, which deals with other types of contracts like indemnity, guarantee, bailment, pledge, and agency. In this video, we will understand how a contract is made and what are the essential elements of a valid contract. To begin with, the very first thing is the proposal. A person, when signifies the other his willingness to do an act or to abstain from doing any act in order to obtain the assent of the other, is called a proposal. Now, when this proposal is accepted by the other person, it becomes a promise. Section 2 subclause A defines proposal. Section 2 subclause B defines promise. Section 2 subclause C talks about the promiser and the promisee. The person who gives the proposal is the promiser, and the person who accepts the proposal to make it a promise is a promisee. Now, when these set of promises carry some consideration along with them, they become agreements, which is defined in Section 2 subclause E of the Act. And when these agreements become legally enforceable, they become contracts, which is defined in Section 2 subclause H. From what we have discussed till now, we infer that a contract is made when two parties, consenting parties, come together to form an agreement where there is a consideration for both the parties and which has a legal obligation to it because it is legally enforceable by law, is a contract. Let's quickly understand what Section 10 of the Indian Contract Act says about the conditions of a valid contract. Now you can see on the screen Section 10 of the Act, which deals with the essential elements of a valid contract. The consenting parties, free consent, there is an offer and acceptance which forms a promise, legal obligation, and lawful consideration and a lawful object. One thing that I would like you to notice that when we talk about consideration, even in terms of agreement or contract, it should be a mutual consideration, which means that the consideration should be given to both the parties. For example, I buy 10 apples from a vendor and pay him 100 rupees. So for the vendor, 100 rupees is the consideration, and for me, those 10 apples that I'm getting from the vendor is a consideration. But if I refuse to pay those 100 rupees, or if the vendor refuses to give me those 10 apples, that means one of us are not getting our share of consideration, and so this will not be a valid agreement or a valid contract.